do you have an order from the Court of Appeal on this issue?
The Court of Appeal, as a matter of judicial notice, my learned friends will be aware, has a way of disposing of any matter.
I don't think we are for argument. I've asked, do you have an order from the Court of Appeal stopping or arresting this judgment?
As we speak right now, no, because the order of business.
You have answered me. You have answered me.
May I finish, Judge?
You have answered me, and I have accepted that answer. I will now ask some of the parties here to respond to that.
May I finish before they respond? Just for good order. My lords and my lady, we do not in the least, I do not in the least want to bring any theatrics or sabotage the administration of justice before you. What has provoked this particular move to the Court of Appeal is the aborting of the hearing on the 4th of June, 2026. And so that my learned friends can respond. On the 7th of May, before you, learned Senior Counsel Professor Aguido Mugai gave me the podium so that then you could address everybody in E586. On that day, you gave, in the presence of everybody here, the 4th of June as a hearing date. So that as they address that, it is common ground that that petition was to be heard before the date to render the judgment was given. Thank you, Your Lordships. And thank you for giving me this opportunity.
The subject matter raised by Mr. Kinyanjui relates to a file which is not before us here. And we have not taken any record in this particular file. But for the purposes of transparency, I will ask the parties who are expecting a judgment from us for their comment.
My lords, my ladies, I have the instructions from the team of the first petitioner, His Excellency Rigathi Gachagua, to make representations on his behalf. We have come here to pick the judgment in the petition before you. We have not received any order from the Court of Appeal stopping today's proceedings. We actually, as a matter of fact, not participating in that matter at the Court of Appeal, and therefore it will be very curious for us to have our legitimate expectations to get a judgment today interfere with a matter in which we are not participating. In the absence of a formal directive from a court higher than this, the Court of Appeal stopping this judgment, we ask you to deliver our judgment as scheduled today. That's all.
Thank you.
Of the 44th petitioners, my lord, I associate myself with petitions made by senior counsel. The fact that that file is not before you, my lord, form the basis upon which this judgment can be deferred. And most importantly, my lord, counsel having not given sufficient reasons, my lord, for adjournment, my lord, or arresting the judgment, my lord, I think the legitimate expectations of the 4th to the 49th petitioners, my lord, is that you render yourself as you set your mind and yourselves to do this afternoon, my lord. We are opposed to that application.
Thank you.
In the interest of time, I will speak for all my colleagues, for the respondents, and we associate ourselves with the submission of learned senior counsel, Mr. Ungoya. Yes.
Thank you.
My lord, on behalf of the third interested party, we associate ourselves with the submissions of the lawyers for the petitioner, first petitioner, and wish that, my lord, you could deliver judgment as it has been agreed before. I thank you, my lord.
Thank you.
Your Honor, on behalf of the second petitioner, We associate ourselves with the submissions of the other petitioners, and we say in the absence of a court order for stay, then we see no need of stopping judgment. That's all. My lords and my ladyship, appearing for the 43rd petitioner, we also associate ourselves with the submissions of Senior Counsel Longoya, and in the absence of a clear order and in respect of our legitimate expectations to deliver the judgment, we then oppose the application. Thank you.
The consolidated petitions. That is a decision of the court, not my decision. Shouldn't the petitioner have abided by that decision? Yes, he did, and yes, he has. The 7th of May, everybody here was present when that decision was made to hear that petition. I'm answering, my Lord, I'm answering because they say that this is something that I've just come up with to scuttle the hearing. It's my rejoinder, with very much respect, my Lord. And I'm not going to take too long. I'm alive to the fact that this court is on a constitutional duty. My Lord, the date for hearing was... I served that application from the Court of Appeal, different to the Court of Appeal's directions. And we cannot say here and pretend, as legal practitioners, we do not know the practice of the Court of Appeal. The Court of Appeal is seized of these proceedings. And this court is subordinate to the Court of Appeal. And I'm answering that issue to defer this judgment. The Court of Appeal being seized of those proceedings, which everybody here is fully aware. My friend has said, yes, he has been served, everybody has been served. So we ought to give deference to that constitutional issue. The other issue raised is that, Your Lordship, there's nothing peculiar, there's nothing out of these constitutional petitions. London Council really, having looked at my petition, never having answered in that petition, Mutomi Thiankolu never filed a single sheet of paper in that petition, and he is appearing for the 10th respondent. Your Lordship, he cannot be heard to say that he has absolutely no reason to see what is peculiar. Your Lordship's you saw the peculiarity of that petition. I'm not going to go. So that, Your Lordship, the petitioner wants to be heard on merit because Article 25C says he should be heard and given that right to a fair trial. As I close, none of my learned friends here, when that petition comes up for hearing, should they ever remove from their pocket the res judicata card. None of you. My Lord, I say so because they are happy to have the judgment today. And I'm going to demonstrate there was no lawful impeachment. Constitutional threshold was never met, and I'm not delving. So none of them, my lords, none of them, no, Prof, please don't point a finger at me. None of them should be heard to say that my client's petition is res judicata. So that, Your Lordship,
Mr. Pinanjay,
yes,
we have given you enough time.
Yes, this is my last remark. This is my last remark. Since the Honorable the DR received this formal communication and was brought to the attention of this Honorable Court, I very believe this Honorable Court should have deferred to the Court of Appeal. And I said, we're not adjourning indefinitely. It's not open-ended. Even give me this afternoon, we'll be heard, and then you can render your judgment tomorrow. Thank you for hearing me.